Alright, we're going to start in about 1 minute, so if you want to grab something to drink, or there's a giant sheet cake out there that has your name on it, so make sure you get a piece of chocolate cake that's as big as your fist. Just want to
you enjoyed your lunch. And again, thank you to Emily and Susie out there for all of the work they've done, making sure that we run on time and keeping us fed and caffeinated. So what we've done is we've moved from kind of the introduction opportunities to discussion yesterday afternoon on concerns and things that we wanted to talk about. Today we've talked about wildlife, species, issues, climate. So we went from macro to micro. So now when Nicole and I were talking about this conference and trying to put the agenda together, it was just, we started, I think, with an agenda that could have been a week. There's so many issues you could talk about. So what we tried to do is funnel this down. And so that's the structure we've had: opportunity, challenges, and what we wanted to end on was to make sure that we talked about how do we formally think about these challenges and try to come to that balance. And so our next panel is on that regulatory structure, processes, and we're very lucky today to have Larry Wolfe, who will moderate this. Larry is a board member of the Haub School of Environment and Natural Resources here at the university. So we're very proud and happy that he could participate in this way as well. He's had a long-standing relationship with the university. He also comes in I guess now a former life from Holland and Hart, where he worked on tax and litigation issues with respect to natural resources, and prior to that he was actually in the Wyoming Attorney General's office in an even more former life, I guess. And in between somewhere in there, as I read his bio, he was somehow deeply involved in helping craft regulatory and tax policies in the state. So the bottom line is, what we can take away from this is Larry's been thinking about this for a long time. And so he was the perfect person, we thought, to really moderate this panel and to kind of guide us through what probably we could spend an entire week talking about, which is the regulatory process itself. So with that, I will welcome Larry and the panel and look forward to a productive afternoon. So thank you.
Thanks, Rob. It's an honor to be here. I'm going to dispense with sort of formal introductions of the panel. One of the great things about being the moderator is you get to choose your friends to come talk. And I've chosen my friends, but also people who have long and deep involvement in these issues. And let me just make brief introductions. Roxane Perruso, who's with Power Company of Wyoming. The thing I admire about Roxane, in addition to her incredible legal talents and her abilities, is that she stuck this out. I mean, I first got to know Roxane in the late of the last decade, and she's still at this. And so there's something to be said for being a survivor and for pursuing your project with incredible diligence. And Roxane, I really do admire your stick-to-itiveness for doing that, and how much you've accomplished, and how much we've, frankly, over the years have all learned from you. Bill Russell and I first got to know each other litigating against each other over mineral tax issues when he was with the Attorney General's office, and I developed a deep respect for him then, and then he's gone on to join the Public Service Commission and is now the chairman of the Public Service Commission. The Public Service Commission plays this incredibly key role, not so much in the direct involvement with wind development, but in trying to look at the interstate issues and at the issues related to how the regulated utilities are considering wind and all of the other generation resources as they do their 2-year integrated resource planning and as they look farther out. So really shaping the future, and the future of regional transmission, regional balancing authorities, and we've asked Bill to address those. Cindy DeLancey and I worked incredibly closely and for 2 years to help craft, as the wind industry roared into Wyoming, and it started, as we heard, about 2006, but it was intense. I mean, if you were here in 2008 and 2009, the impression most people had was that there was going to be a wind turbine on every ranch, every farm was going to be covered. The state was just going to be wind turbines from Pine Bluffs to Evanston. And of course we know that didn't happen, but what was going on then are these key decisions that were made, and were made with a lot of input from many, many parties about how we should regulate at the state level wind farm development, and also what role should the counties play in this, because the counties demanded a key role in this, and Cindy was the executive director of the County Commissioners Association, and so she was deeply involved in all of those issues. And now she is the president of the Wyoming Business Alliance, which has a statewide view from many of the key businesses in the state, and wind development is obviously central to what the Business Alliance is interested in, as the economy in Wyoming goes through some of its profound changes. Jen Scoggin and I have been partners in the practice of law. I've admired Jennifer and her work for many, many years. What she never talks about, and most people don't know, is that Jen has been one of the key figures in all of Wyoming in working with the Industrial Siting Act, not just for wind projects, because Jen was the lawyer who permitted the Duke projects up in Natrona and Commerce County, has worked with wind developers now in a large number of the big projects, but has also seen the industrial siting process for lots of other different kinds of undertakings, and those experiences have informed her and the clients she's worked with and the regulatory agencies about how this process ought to work. And so that's one of the things we're going to talk about. The other thing you should know about Jennifer is that she has made an enormous commitment over her career to something that's a very unheralded undertaking, which is the regulation of the conduct of lawyers. And she has been the chairman of our professional board of responsibility, which oversees lawyer conduct, and she continues to serve in a key role in that. And this has been both a passion and a commitment to the bar and to society that nobody else ever talks to, because it looks like, what do you mean, do lawyers ever misbehave? Of course not. So that's our panel. We're going to start with Roxane. Roxane is going to tell you about her project. We're going to let each of the panelists talk for about 10 minutes or so, and then we'll have a discussion among ourselves, and then we'll have about a half hour of question and answer. Roxane?
Good afternoon, everyone. Thank you, Larry, for that very nice introduction. This has been a great couple days, and I'm really happy to start off this panel with a high level, and I want to emphasize high-level overview of the regulatory and permitting framework that was applied or has been applied to our project over the past 10 years. And since we don't have several hours to go over that, that's why it is going to be kind of a high level. But we would like to put into the regulatory framework into context. So just to give you a little background, our wind project is being developed by Power Company of Wyoming, and Power Company of Wyoming is a wholly owned subsidiary of the Anschutz Corporation, which is privately held. Now, the wind farm actually continues a very long history that the company has had with Wyoming for the past 50 years. We have ranching and agricultural operations in Carbon County, and we have significant oil and gas operations in both Powder River Basin and Green River. So the wind farm that I'm going to talk about today, and also our transmission system, are really just the latest addition to our investment in Wyoming. I'm going to tell you a little bit about the project before we dive into the regulatory framework. The project you've actually heard a little bit about from Ryan and from a few other people on various panels. But the project is located on about 220,000 acres of a 320,000 acre ranch that we own that's located south of Rollins and Sinclair. The project will have up to 1,000 turbines, 3,000 megawatts of nameplate capacity. And the project is being built in 2 separate phases of 500 turbines apiece. The construction is currently underway on phase 1, and you heard that Oftedal is our contractor on that construction occurring now. And we plan to move directly into phase 2. It really is just one project. We talk about it in phases to help segment it a little bit. The project includes an on-site quarry, a rail facility, and an internal haul road that's designed to keep traffic off of local roads and highways. Now, I mentioned that the wind farm covers a total of about 220,000 acres of the 320,000 acre ranch. But I think it's important to say that the final long-term disturbance after construction and interim reclamation is only 1,600 acres. And so the ranch will continue to be a working cattle ranch even after the wind farm is constructed. The project will produce, we're estimating, about 12 million megawatt hours of electricity a year when it's fully built out. And it represents a $5 billion capital investment in Wyoming. The wind project's made up of a combination of private lands, which on the map are reflected in the green, BLM managed lands, which are reflected in the yellow, and then there's some interspersed state lands. And because of that checkerboard configuration, there are 3 different applicable permitting and regulatory processes that the project has been subject to over the past 10 years. So first, we had to obtain authority from the federal government. to develop the wind farm on the BLM managed lands. And the BLM has the responsibility to comply with the National Environmental Policy Act. And actually, that's only one of many statutes that the BLM has to comply with. The BLM determined that in order to comply with NEPA, it needed to do an environmental impact statement on our project, which is the highest form of an environmental review. Now, that means it's a multi-step and multi-year undertaking, and it's very expensive. As the project proponent, PCW had to file a right-of-way application. We also had to produce a plan of development that the BLM could consider in the EIS. We entered into a BLM cost recovery agreement, so all of the BLM staff time was compensated for by us. And in addition, we paid for a third-party EIS contractor that operated under the supervision of the BLM in preparing the EIS, although we paid for that. Now, in an EIS, sorry, I forgot to advance my slide. So that's kind of what I just went over about BLM managed lands and how you have to comply with NEPA. Now, these are the elements, and actually this might not even be a comprehensive list, but in an EIS, every type of resource is analyzed. And I'm not going to read you this whole list, but the EIS addresses areas which included cultural resources, socioeconomics, visual resources or viewsheds, wildlife, water, vegetation, transportation. Every area that you can think of was analyzed by the BLM in the EIS. And the stack you see in the picture is just some of the environmental analysis that the project has undergone. And I actually was going to bring that stack today, and thinking it would be kind of a nice visual, but to be honest, when I went to the office Sunday to start packing all the boxes, I thought, no, can't do it. So there are significant opportunities for public involvement during this EIS process. So state and local governments and tribes participate in the development of an EIS as formal cooperating agencies. Now, a few, not all, that participated in our EIS were the state of Wyoming, Carbon County, and the city of Rollins. Now, the general public also gets to participate as well. And they participate through either feedback that they provide to the local governments, or they can actually participate directly by commenting both in writing or attending meetings, public meetings, and having their testimony and comments recorded. So for us, our project-wide EIS started in about 2007, and the project-wide EIS was issued in 2012. Now, I think of the project-wide EIS like a subdivision plat. It laid out where infrastructure could be located, where the wind development areas were approved, and then it set out all of the requirements that we were going to have to meet related to impacts, mitigation, avoidance, etc. And then the EIS, so we weren't done then. We had a record of decision, but we weren't done. The EIS then required that there was going to be a second level of environmental analysis that our project would be subject to. And that required us to submit what we call SPOTs, because we had to make up a new acronym, can never have enough, and they're site-specific plans of development. And so if you think of this as going back to, say, regional building with your house plans, we had to then submit to the BLM our site-specific plans for the rail facility, for the haul road, for the first 500 turbines. And the BLM did a second round of analysis in environmental assessments where they screened our plan back against the EIS to make sure that we had met all the requirements that were set out in the EIS, and that we had done what we said we were going to do and were required to do. Now, as far as public participation to date, there have been 14 open houses associated with just the BLM's review of the project. Phase 1, as I said, is fully permitted, and we're in the process then of submitting our site-specific plans for Phase 2, and there will be then additional opportunities for the public to comment during that time. So now I'm going to move to the other two permitting processes, which are Wyoming state and county processes. And you should know that Wyoming has a comprehensive statutory and regulatory system and requirements that the Chokecherry project had to comply with. These permitting reviews, state and county, also look at every conceivable aspect of the impact of wind development. And I think it's fair to say that Wyoming is allowing wind development only on its terms. Now, just to give you an overview, there were certain pre-application meetings that were required. I'm going to talk about our Carbon County conditional use permit process first. We met with planning and zoning, emergency response, road and bridge, weed and pest to make sure all those agencies understood about our project and that we were meeting their needs as well. We had to file written and legal notices regarding to mineral owners and certain landowners. And then we had to file a very detailed application, which I won't go into all of the requirements, but it was quite detailed. And then there were two public hearings. The first hearing was with the Planning and Zoning Commission, and there were opportunities for public comment at that hearing. Planning and Zoning then made a recommendation to the Carbon County Commissioners as to whether they recommended the Commission approve the project, but we then had a second hearing in front of the County Commissioners, and again, that was also a public hearing. Now, ultimately, the Carbon County Commissioners did approve our conditional use permit, and they made very detailed findings that are set out in both an opinion and a resolution from the board. We then went from obtaining our Carbon County permit to going through the Wyoming state process. Now, Wyoming's state permitting process is also extremely thorough and allows for public participation at many levels. So prior to our hearing, we hosted 7 public meetings to disseminate information about the project and again, opportunities for comment. And they were held in Rollins, Saratoga, Baggs, Medicine Bow, Laramie, Rock Springs, and Casper. There are very statutory guidelines, again, about all the various notices that you have to provide to the public. And there's also an opportunity for cities and towns and districts to become formal parties to the process. So we had 15 entities that were parties to our ISC permitting process. This all culminated in a 2-day public administrative hearing that was held in Saratoga. It was held in front of the entire 7-member ISC council, and there was a hearing officer who acted like a judge would at a trial. And it was run like a trial. PCW, we presented witnesses, and those witnesses, there was an opportunity for the parties to cross-examine our witnesses. We presented 8 different witnesses and who addressed project approvals and studies, and I'm not going to name everything, but this is an idea of what was presented. Project design, construction and operation, decommissioning and reclamation, socioeconomic analysis, workforce housing plan, and environmental, and there's 7 different areas under environmental relating to soils, vegetation, wildlife. And then we also address safety, both workforce and public safety. Now, as I mentioned, all 15 parties participated, and they had the chance to also speak and provide comments. So after the 2-day hearing, the ISC Council deliberated in public in front of everyone. And I'm happy to say for us that all 7 members, they voted unanimously to grant us our permit. They issued a 67-page order with all of the council's legal and factual findings. Now, our ISC application and that order are all available online. We also have ongoing obligations to both the county and the state to provide updates and written reports, which we are doing. So that's a very quick overview of the regulatory process. I want to just touch briefly on some of the things that came out of that process. For instance, and we've talked a lot about the impacts, and you've heard a lot about that. So what came out of the process for us are some of these things. So for sage grouse, we're currently involved in doing a VACI design study, so a before-after controlled impact study. We have 6 years of pre-construction data on sage grouse, and we have agreed to continue the monitoring through construction and then 5 years post-construction. So we are contributing to the scientific research on sage grouse and what impacts, if any, wind development has on them. We also moved turbines out of sage grouse core area. We actually gave up some of the best winds in the entire project in order to do that. And we have also agreed to put 26,000 acres of private lands that are on the ranch that are located in sage grouse core area under a conservation easement that will permanently prevent wind development and preserve sage grouse core area. Some other examples with respect to eagles and other avian species, not just eagles, but we have 5,000 hours of bird surveys that we've done over the years. We have multiple years of nest surveys. We can tell you where every nest is on our 320,000 acre ranch. We actually used avian radar, and it's the first time that I'm aware that a developer has used avian radar pre-construction. And we used the avian radar to find out what level, for instance, migratory birds were passing over the project. And we were really happy to find out that for the most part, they're flying above the windswept, the rotor windswept area. We've mapped areas of high eagle and avian usage, and then we have now designated those areas as turbine no-build areas. So out of the 220,000 acres that the wind farm covers, 104,000 of those acres are designated as turbine no-build areas. We've employed nest buffers, setbacks from ridges, seasonal curtailment, and carrion removal. We've developed a comprehensive eagle conservation plan, a bat bird conservation strategy, and we applied for an eagle take permit, which then meant that our project went through a second EIS, strictly to look at the eagle take permit. So that's just some examples. Another important area we've heard about is viewshed. We had a lot of public feedback provided in the permitting process that led PCW to redesign our turbine layout. We moved turbines further away from Teton Reservoir, which is used for recreation. We moved turbines away from the river, and we also moved them away from the Overland Trail. We have worked very hard to minimize visual impacts as much as possible, and we used visual simulations in our open public meetings. Now, the vast majority of the wind project will not be visible from public access points. In addition, and this is what this slide addresses, the entire cost of decommissioning and reclamation will be bonded for using surety bonds to assure that the project, when it's no longer economically viable, will be decommissioned and the land will be returned to the way it was before. Now, our obligation is to post a total of $265 million in bonds. Currently, we have $90 million in bonds posted to cover the construction that is currently going forward. I won't spend a lot of time on this because you've actually heard from Dan Noble and I think from Ryan, but our project does have a lot of good fiscal economic impacts for the community because of the 3 tax revenue streams that the project is subject to. We will pay about $850 million in tax over the construction period and the first 20 years of operations. This is just our chart of the permitting milestones. We have met the ones for phase 1 and phase 2 are the bottom 4 columns there in environmental analysis. 1,500 is the approximate count of separate requirements that we have to meet to avoid and minimize impacts of the project. There have been over 70 to date public meetings on the project. At this point now, when we say there's going to be another public meeting, most people in Carbon County go, why? And that doesn't count the many other presentations that we've given to Rotary clubs and Lions clubs, and basically anybody else who wants additional information about the project. So, based on our experience with this project, the state, the county, the federal processes assure that wind projects avoid, minimize, and mitigate potential impacts to wildlife and the environment as much as practicable. Now, thank you for letting me talk about our project, and now you're going to have a chance to hear from the real experts on Wyoming's regulatory framework. Thank you.
Thanks, Roxane. That was informative, and I think it's a good example to show you all how the regulatory process works and how impactful it is to these projects and getting them off the ground and fully sited. Thank you all for being here. Thank you, Larry, for asking me to participate on the panel. I'm going to stand just because I find the chairs a little bit awkward. I feel like I'm sinking back into them. But what I'd like to do is I'd like to drill down a little bit on the Wyoming industrial siting process, which is the state permitting process that these wind energy projects will generally need to go through. And as Larry mentioned, I have been working in industrial siting for probably 10 or 11 years. I started with some of the first substantial wind projects, the Duke Top of the World and Campbell Hill projects I assisted with, but I've also done non-wind projects, the Simplot expansion, Rock Springs, the FMC Granger optimization project, and I think I was also involved in maybe a Williams gas expansion project too. So I've kind of seen this from all sides, not just the wind energy side. And my experience when I first started, the Industrial Siting Act looks a little bit different than it did back in 2007. So I'm going to just start and kind of give you sort of a background of the Industrial Siting Act and the council, and then I'm going to sort of interject with some of my notions about how things have changed and in my opinion for the better. So the Wyoming Department of Environmental Quality administers the Wyoming Industrial Development Information and Siting Act and its rules and regulations. And in fact, there's a specific division in the DEQ called the Industrial Siting Division that is actually the staff or the processing folks who receive these applications and process them and administer them and all of that. The Industrial Siting Council is the adjudicatory arm of that division. It's made up of 7 members. They're appointed by the governor. They generally try to look for people with different backgrounds in different geographic locations of the state so that they're sure that they're getting all different viewpoints when they're considering these applications. And the council reviews the application materials and makes the decision to grant or deny the permit for construction and operation of the industrial facility. And what this is really all about, the bottom line, is the industrial siting process. It's a socioeconomic and environmental impact analysis of the planned industrial facility. It helps make sure that the applicants are talking to the state and local authorities about the project, so that it can help folks prepare for what's coming. Wyoming is a small state with a small population. You can't just drop a big project in their laps, especially at the county level, and be able to muster all of the resources and prepare for the incoming workforce and all the impacts that these facilities bring, both on a temporary and a long-term basis. So that's really what it's about. It's about communication. So what sort of facilities does the Industrial Siting Council have jurisdiction over? Well, they're kind of divided into two types of industrial projects. There is a construction cost component where a facility would be jurisdictional or is jurisdictional to the Industrial Siting Council if it meets a certain construction cost threshold. I think currently it's around 211 million, somewhere in that area. When I first started assisting with wind permitting, there was no, it went based on a construction cost threshold. There wasn't a specific definition of industrial facility that was applicable to wind projects. Well, in 2010, that changed. In 2010, what happened is a section of the Industrial Siting Act was amended so that it was clear that in addition to certain enumerated types of facilities that are considered industrial facilities for which there's Industrial Siting Council jurisdiction, certain types of wind projects would be. And those are commercial facilities generating electricity from wind and their associated collector systems that consist of 30 or more turbines, or expand an existing facility to meet or exceed that 30 turbine threshold. So that's generally what the Act says now with respect to wind projects. And the reason for that change is when I initially started out, there was a fear, if you will, that people would propose and build wind projects in phases, and so that they wouldn't meet the construction cost threshold. They would just be constructing certain aspects of the project at a time, and so they might be able to slip under the Industrial Siting Council jurisdiction. Well, that's no longer the case. We have a pretty good definition of what types of wind energy projects are now jurisdictional. Additionally, and Cindy will probably talk about this in a little bit, the Industrial Siting Council has jurisdiction regarding wind project facilities that could be permitted at the county level by boards of county commissioners that refer these projects to the Industrial Siting Council because for whatever reason they don't feel they have the expertise to maybe consider and permit those. And so Cindy will talk about that, I'm sure. So an industrial siting permit must be obtained prior to commencement of construction, but there are some exceptions, if you will, for temporary changes. And those are defined as changes that usually don't last for longer than 90 days. Things such as conducting required studies and tests of the property, constructing access roads, constructing routes for non-utility purposes, and uses for securing geologic data. The best thing I found is that if you're in question about whether or not what your preliminary activity is with respect to, is it something that can be done under this temporary waiver period, it's always best to check with the Industrial Siting Division. They can really guide you. I've had some clients that want to do certain things, and then we talk to Industrial Siting, maybe that's a little bit beyond what you should be doing for the temporary purposes. Also, another change with the Industrial Siting Act are now notices have to be provided, certain notices prior to submission of an application. Local governments must be advised and provided 30 days prior to submitting the application. They have to be given an opportunity to submit comments. Local governments, in this context, it's a pretty broad definition. It includes counties, incorporated municipalities, school districts, and joint powers boards that you would anticipate would be impacted by the project itself. In addition, surface landowners and mineral right owners now have to be provided notice of the project 30 days prior to submission of the application. So what does the industrial siding permit application address? And Roxane touched on this a little bit, but it's a very robust application process. The information that needs to be in there are things such as a description of the project, the location, the construction schedule, a socioeconomic baseline for the anticipated impacted community, an analysis of the potential socioeconomic impacts. It looks at potential environmental impacts, but luckily for Roxane, common data and information that would be common to different sorts of permitting can be shared, so it doesn't all have to be a separate process. With respect to wind energy facilities, there are certain things statutorily now, additional information that must be supplied in the industrial siding application relative to wind energy facilities that are not required of other types of facilities that might be permitted under the Industrial Siding Act. And those include the applicant must provide a site reclamation and decommissioning plan, and that reclamation and decommissioning plan is to ensure the proper decommissioning and interim and final site reclamation during the construction and operation of the facility. Costs are actually proposed by the applicant, reviewed by the director of the DEQ, and then the Industrial Siding Council as well. These reclamation and decommissioning plans must be updated every 5 years, must be signed off on by a Wyoming licensed engineer. Additionally, a financial assurances plan must be provided if you're going to construct a wind energy facility. That's to assure that the decommissioning and reclamation aspects of the project will actually occur. The forms of financial assurance can be corporate guarantee, letter of credit, bonding, and then finally, a wind energy applicant must show financial capability to construct and operate the project. And like I said, those three things are specific to wind energy development. They're not required for other types of projects. And I think those were added as when Larry was talking about this big flurry of wind developers that came to Wyoming in 2006, and we thought there was going to be a turbine everywhere, the sky is falling, and so in order to address people's concerns, the biggest concern that was raised at that time was, well, what if we get these people in here who put together a project and then they can't really afford to do it, so then they just kind of leave it there, and so then what's the landowner to do? And is the county going to have to absorb that cost? We need to make sure that we're getting responsible developers, people who can come in and afford to reclaim and decommission so that those burdens aren't on the state and the county, and also they can afford to construct and operate the facility itself. And I know some of those early wind applications, not ones that I worked on, there were instances in which there were smaller companies trying to put together wind projects who really weren't adequately financially backed. And the addition of these requirements was meant to sort of address that, so that now you can't just simply have a fax and a phone in some small town in Wyoming and put together a wind project and sit on your application or sit on your permit until you figure out how to flip the project. What the Industrial Siding Council wants to do is issue permits to viable, bona fide projects that they know can be responsibly developed. And so that's what that's all about. I better speed up here if anyone else is going to have a chance. So the industrial siding process has two types of permits, a Section 107 and a Section 109. Section 107 is kind of an abbreviated process that takes about 60 days from submission of the application materials, and it's more of a local government focused permit application. It has a lot of the same things as the 109, but really the focus is on reaching out to counties and local governments and talking about impacts and mitigation of those impacts. There is a public meeting and a public hearing involved with that. The danger of the 107 permit is that if two or more local governments deny or do not like the mitigation recommended and committed to by the project applicant, the permit is dead. It will not be granted. The 109 permit That's a very robust permit. It takes a little bit longer. It's about 120 days from submission until the granting or denial of the permit. It's kind of a little mini NEPA review, gets into a lot of the environmental looks, wildlife, scenic resources, land use, transportation, solid waste. It also goes into the socioeconomic drill down, so there's more information there. There's discussions about impacts to health and hospitals, agriculture, police, fire, all kinds of things. So it's a real robust look at potential impacts of the project, big analysis. The other thing, one of the beneficial things with the industrial siting process is after the permit applications are submitted, the permit applications are then distributed to some 17 state agencies for comment and review. And so the state agencies receive the applications and they look at those aspects of the application for which they might have a jurisdictional component or they have an expertise, and they can provide comments to the Industrial Siting Council with respect to proposed mitigation or other recommendations or permit conditions that might be placed in order to assure responsible development. Now, copies of the state agency comments are then provided to the applicant, so the applicant can then respond to those and let the council know what they're doing, what they're committed to doing to addressing the concerns, or if there's a misunderstanding or somebody didn't see something in the application, those can all be addressed. So then, as Roxane alluded to, there is a contested case hearing with respect to industrial siting permitting. You have evidence, you have witnesses, it's just like a mini trial, if you will. And it's the responsibility of the applicant to put on their case to demonstrate that this is, that it meets all the requirements of the Industrial Siting Act. Parties to the contested case hearing can include, and these are set by statute, affected counties and local governments, affected landowners, the applicant, the Industrial Siting Division, and nonprofit organizations who have chapters in Wyoming concerned with promoting conservation, protecting the environment, promoting consumer interests, representing commercial, agricultural, and industrial groups, and promoting the orderly development of the facility. If you don't fall into one of those categories, you can still provide comments during the public comment period to the Industrial Siting Council. Also, any person can make what we call a limited appearance, and that's providing written comments to the Industrial Siting Council prior to closing of the evidence during the contested case hearing. However, just because you would provide your comments in a limited appearance capacity, it does not make you a party, it doesn't entitle you to party status, and it's important to note that no other state agency other than Industrial Siting Division can be a party to the proceedings. Now, the council can ask for representatives of various state agencies to testify, as can the applicants, but anyway, I better hurry, I'm sorry. Okay, my last comment. The Industrial Siting Council shall issue a permit if it finds the four things with respect to wind energy development. The proposed facility has to comply with all applicable law. The facility will not pose a threat of serious injury to the environment nor to the socio and economic condition or inhabitants or expected inhabitants in the affected area. Will not substantially impair the health, safety, or welfare of the inhabitants. And in the case of wind energy, the applicant has the financial resources to decommission and reclaim the facility, and the applicant has financial resources to construct, operate, and maintain the facility. And I'm out of time, I'm sorry, but hopefully that gives you a little bit better view of the robust nature of the analysis done at the state level under the industrial siting process for wind energy facilities. Thank you.
Well, thank you for that, Jen, and I think everyone can see that this is an incredibly complex, legal, very procedurally driven exercise. So what I guess will bring to the conversation, and thank you, Larry, for that nice introduction. I want to take you a little bit of a step back further in my wind story than where Larry started it. In 2006, I lived in Carbon County. I had my own law practice, and things were going great guns in Carbon County. And I got this wild idea to run for county and prosecuting attorney. So I signed up, I paid my $25, I campaigned, and I won. And so I take office in 2007, and as part of my responsibilities, in addition to dealing with all the criminal aspect of the office, the county and prosecuting attorney provides legal advice to the elected officials. And so I just thought it was worthwhile to kind of share this story of my win story and the journey of this for me, is because it really exemplifies, in my mind, all that's good in Wyoming, that so many good ideas just kind of come from casual conversations amongst friends. And what happened was I was visiting with one of my clients at the time, who happened to be a county commissioner, and said, hey, I'm going to this meeting with a wind developer company, do you want to come along? Well, that decision to say yes changed my life. Totally changed everything for me and my family. And I go to this meeting, we start talking about projects and Carbon County's exceptional wind, and little did I know at that time that I had just found myself in the front row seat of ground zero for wind energy development in Wyoming. I thought being a prosecutor was about, DUI and larceny cases and, juvenile cases. Little did I know that I would become, immersed in this rapidly developing, wildly interesting, whole, wide open legal space related to wind energy development and what that looks like in Wyoming. So I go to the meeting, I realize, oh my goodness, we really don't have any regulatory framework for any of this. And as Larry alluded to, it was very, almost overwhelming to hear that we had such beneficial wind and there was such interest in developing in Wyoming, that I was so blessed at the time to have clients that were committed to being forward-thinking problem solvers, to say, the world is changing around us and we must need to change with it. So instead of trying to resist change, let's embrace it, let's position ourselves to be ready. So I started working with the Wyoming County Commissioners Association. They had a commissioner working group looking at some of these issues to kind of figure out, well, what do we do? And so Carbon County was kind enough to allow me to participate with the commissioners, and it really made sense, knowing that there was such interest in development in Carbon County, for us to take a leadership role in kind of sorting some of this out. So my point in sharing this with you is, as a county attorney, as an elected official, in Wyoming, people can make a difference in public policy. And it's such a benefit to work with citizen legislators, because they really care and they really want your input and they want to know what's going on in your communities. And the next thing I knew, I found myself testifying in front of legislative committee meetings and working on statutes and all kinds of things that never in my wildest dreams, when I thought I was going to be a prosecutor, that I ended up having this very, very deep set of knowledge that I'm very grateful for. And that's really where I found my passion professionally. Is I love working in the Capitol. I love working on public policy. And it was such an interesting time in Wyoming. And when I look out in the audience and see people like Ryan Lance and Mary Flandurka and Chairman Case and Chairman Madden and Larry, we were full on 100% win all the time, having meetings, trying to figure out how do we get this right. And so just a couple of points I wanted to raise today. Basically, walking you through the county piece. We just heard Jen's overview and Roxane's overview of the multi-layers of review and regulatory framework that many of you might be asking, why do we need another level? Why the county? What role did the county have to play in this? Well, local government is really the local office of state government. And to be able to have a framework at the local level to not just rely on folks in Cheyenne to figure it out for us was a value that was extremely important to the county commissioners. And I know we have Commissioner Espy and Commissioner Grant in the room, and I'm sure that they'll echo my comments and say that, having that local input is absolutely a way to ensure that we have the ability to engage in community conversations. And so I just wanted to give maybe a little bit of a different perspective from what we heard from the developer panel yesterday. as far as, the regulatory process can be overburdensome, and that certainly was not the intent. The intent for the county to get involved in to join the conversation was to make regulation that helped facilitate the industry and promoted good governance, and to really help that preparedness, that level of readiness to have the projects that came to Wyoming to be successful. And some of the things that were contemplated that ultimately ended up in the statute was, making sure that there was a trash plan. What do we do when there's all these people and all these workers? Making sure that there were adequate setbacks, that turbines weren't built right off, somebody's front steps. Notice to mineral owners, access to the property, road use agreements, first responder emergency response plans, knowing where the turbines were. These were the basic kind of nuts and bolts, fundamental elements that were just designed to facilitate cooperation and communication. And again, these were a set of statutes that were developed with industry input every step of the way, that we were able to come together as a group to figure out, what makes sense. We don't want to do something that's going to slow you down or prohibit you, but we want to make sure that if there's a problem, somebody's injured on the job site, that we can actually tell the ambulance where to go. And have that ability of communication was just so incredibly valuable. And the community of Carbon County was very interested as well in this time in learning more. I'm so pleased to see so many people from Carbon County in the audience, like Stacy and Scott. People in Carbon County were so interested in this industry and wanted to learn more about it that they were very engaged in it. And so I'm very, very proud of the piece of work that was done as far as setting the county minimum standards. It's a piece of legislation that I think is good. I also, in addition to just, again, like that nuts and bolts kind of, governance and component into, of how this all works, just providing information, it also provided a framework that the counties didn't find themselves in competition with each other. That we wanted to have the counties be in somewhat of a level playing field, that it wasn't, Carbon County's regulations do this, and Albany County doesn't have any, so, we're just going to build on this side of the line. And it was a very thoughtful approach to ensuring that we had regulation that was smart, and again, as I said, promoted good governance. And it also gave the ability for counties, it's called the minimum standards for a reason, that these are the thresholds that you'll find in all 23 counties in the state. So that way there's clarity and a roadmap for developers, and there were no surprises. But it also left the door open that if there was something unique to a community, which we all know in Wyoming that one size does not fit all, that we were able to give that outlet to be able for a community to put its own special flavor on it. And Power Company Wyoming, having gone through the county standards process, it really facilitated a lot of time and discussion and relationships. And I've known Roxane now too for about 10 years, and she and I got to know each other very well. And she showed up in the county attorney's office with her wind project, and we were all just like, oh my. So it was a lot going on, and to have companies committed to Wyoming, committed to our economy, making these kinds of incredible investments, Rocky Mountain Power, Power Company of Wyoming, so many good operators that are trying to provide opportunity for our next generation of Wyomingans. Having these set of standards that we're able to guide the conversation in a constructive way, I think is, again, something that Wyoming should be very proud of. So with that, I will turn it over to them.
Thank you, Cindy. You may have noticed that some of my fellow panelists are sitting on the edge of their chair. Originally, I thought it was because they were so engaged in subject matter. I have since learned that if you sit all the way back, you sink so low that the probability of getting back up in your first attempt is less than 100%. So I'm going to save you the optics and remain seated. Larry asked me to speak a little bit about regionalization of the electrical grid. And before I get into that topic, I want to take just a moment to tell you where I'm coming from in my official capacity. The Public Service Commission is a quasi-judicial body that regulates public utilities in Wyoming. We are first and foremost economic regulators. We are agnostic as to the fuel type used to generate electricity in the state. In other words, we do not pick winners and losers as we're sitting at the bench making decisions on the utilities. And it would be more correct to describe us as more reactive than proactive. We do not direct utilities to go out and to choose a particular kind of energy. They come to us with their plans and we decide whether or not it's in the public interest. So that being said, to talk about regionalization, I think I'm going to approach it by talking about three things. First, I'm going to give you an idea of what a regional electrical grid is. And then I'm going to tell you what's happening right now in Wyoming regarding regionalization. And third, in order for wood producers to understand why the subject is important to you, I'm going to give you a flavor about how the regional energy wholesale markets work that are embedded in all of these regional grids. And by the way, for those of you who are not familiar with the regional energy markets, there's a surprise ending. And that's kind of exciting for me because there aren't a lot of there's not mystery and intrigue in utility regulation, so today's a good day. Okay, to talk about the regionalization of the grid, you can't do that without talking about regional transmission operators, or RTO, and independent system operators, or ISO. Both types of organizations have different roots, but today they are virtually the same thing, and so I will refer to them interchangeably. An RTO is an independent organization formed by a group of transmission owners to operate and manage the larger grid formed as the transmission operators come together. So they're independent and they manage the new larger grid. The theory is that the independence will promote equal access to the grid and to the energy markets, and that the larger footprint of the grid will promote greater efficiency and reliability. There are also some that would claim that it also promotes economy. That's a little more arguable and is probably not the right subject for this particular venue. The three primary roles of an RTO are transmission planning, operating the grid on a day-to-day basis, and operating the wholesale energy markets. These RTOs and ISOs are prevalent in the eastern half of the United States, with the exception of the southeast corner. They are practically non-existent in the western states, with the exception of California. And so that includes Wyoming. We have no regional grid in Wyoming at this time. But that could change. There are currently two initiatives that are ongoing that could bring regionalization to the state. The first one began in 2015 when Pacific Corp started entering in talks with the California ISO about joining them. Pacific Corp is the largest electricity provider in the state, and they do business as Rocky Mountain Power. Their footprint includes parts of Wyoming, Utah, Idaho, Washington, Oregon, and a small part of Northern California. The negotiations as far as the economics of joining the ISO and the technical challenges of joining the ISO have been at pretty much a standstill now for over a year. And that's because the states involved in this footprint, the states that are going to have to approve the marriage of Pacific Corp with the ISO, have been pretty much at a standstill on the threshold issue of governance. And the problem is, California's ISO is different than every other one in that the ISO is a creature of California statute. And the Board of Governors are appointed by the Governor of California. And that calls into question maybe the principle of independence. There are many forces in California that are digging in, not wanting to let go of control of the ISO if it goes regional. And there are states, including Wyoming and Pacific Corp's footprint, that are not very receptive to a Western electrical grid that is controlled by the state of California. So I'm not ready to declare that initiative dead, but it is certainly on life support. On the other side of the state, more to the east, there's a new initiative, and that's between the Southwest Power Pool, which is an RTO that is just to the east of Wyoming and Colorado and extends further north and south along that line. There is a loosely organized group of transmission operators and electric utilities in Colorado, a large part of Wyoming, and to a lesser degree in Nebraska, Utah, Arizona, and New Mexico. They call themselves the Mountain West Transmission Group. They have been in talks for quite a while trying to figure out if they want to form their own regional group or maybe join the Southwest Power Pool. They made the decision earlier this summer that their choice was to join the Southwest Power Pool, pending further talks. And just last week, they announced that they are ready to move into the regulatory phase to seek approvals. And those approvals must come from the federal government, the FERC, and also from any state in the footprint that has a public utility that would be affected by this regionalization, and that includes Wyoming. So we're just at the beginning of that particular process, but it could result in about half of Wyoming being part of a regional ISO. So why do you, as a wood producer, if that's what you are, care? To give you one reason, I want to explain to you how the regional markets work in these regional grid organizations. Any producer that is within the footprint, and in some cases outside the footprint, can bid in to the energy markets that are operating. And when you bid in, the most robust bidding happens in what they call the day-ahead market. So today, Tuesday, you would be bidding on what you have to sell and what you would like to sell on Wednesday. But you can't just say Wednesday, because the bidding goes hour by hour. And so let's say that you're a wind operator and you want to bid in for the 1 o'clock hour tomorrow afternoon. And you decide you want to bid in 10 megawatts at $10 per megawatt hour. And then there's in the next county there's a combined cycle natural gas a generator that wants to bid also 10 megawatts, but his bid is at $20 per megawatt hour. And in the next county, there's a coal producer, and the coal producer also wants to bid 10 megawatts in the 1 o'clock hour at $30 per hour. Well, when it gets close to that 1 o'clock hour, the system operator is going to look at the demand for the 1 o'clock hour. And let's say they determine the demand is 25 megawatts, which is 5 megawatts less than the 3 bids that went in. The way the energy is going to be dispatched is the cheapest offer is going to go first. So the wind is going to go first at 10 megawatts. The natural gas is going to go second for another 10 megawatts for a total of 20. And half of the coal bid is going to go in 5 more megawatts at $30. Now, here's a surprise. Only one of those generators, one of those bidders, are actually going to get paid what they bid. And that's the coal. Because what they use is a kind of pricing where they look at all the bids, and for each hour, everyone gets the highest bid. So even though the wind bid at $10, they're going to get $30. And the natural gas bid at $20, they're going to get $30. And to me, that sounds kind of like a windfall. And I did just see the hook in the back, so for now I'm going to leave it at that, and I hope to hear your questions. Thank you.
That's almost, I hate to leave that, just discussion hanging because there are a lot of questions that come out. Let me just make a couple points and then we're going to open this up for questions from the audience. And the first is, going back to my introduction, I think if you sit here, as you sit here today in late 2017, if you look at our regulatory scheme for wind, it is the product in large measure of Roxane's incredibly patient and thoughtful work with just a huge variety of groups over a critical period of time in 2007, 2008, 2009, and 2010, in which everybody was looking to Roxane and her client for guidance and advice and direction on how we should go about doing this. And Roxane, I never saw her lose her patience in all of that. She just was there at every single meeting and every gathering and every meeting with the legislators and the governors to help, and the governor to help craft that. And then Cindy brought in really this whole piece of how do we deal with the counties. And it's easy to sit here in 2017 and say, you know, why does a county have a role in this? Isn't it duplicative of what the industrial siting does? But my answer to that is that in 2008 and 2009 and 2010, there wasn't any way the politics would have allowed the counties to not have a role. It was absolutely essential to the ability to construct a regulatory regime, and we were constructing it basically out of whole cloth without giving the counties a significant role. And so my question to the panel, before we start answering questions, is, okay, do we need to make any changes today or propose them for the 2018 session or beyond to what was constructed now almost a decade ago? And second of all, I'd like to get to this notion that Mr. Lay advanced yesterday, which is that we need some kind of statewide planning, zoning analysis undertaking of all of the potential wind development sites in the state. So I don't know, Roxane, you want to take one or both of those and start with that? And I know, because I've talked to Cindy and Jen about particularly the first question as well.
Well, with respect to does there need to be, I guess, any changes? We found, as I said, the processes that are in place at the state and county level to be just very, very good. And I want to especially recognize ISC and DEQ, and I know I saw Kimber here earlier. They just worked with us every step of the way. The county commissioners have been great, the BLM has been great. Our biggest challenge has been to have patience with the process because it is a process. The only thing that I think would be good would be to do a review to make sure that the requirements are consistent. We actually did not run into any inconsistencies with the county or state requirements, but that would be a good review to do. We did have a couple areas between, one that I can think of, between the BLM's reclamation standard and the state reclamation standard. There was a different standard, but again, both the BLM and ISC worked with us to resolve that in the process. So that is the only thing I can think of, is to do a review to ensure that there aren't inconsistencies. Luckily, we didn't have many. On the second question, there have been efforts before to do kind of blanket, I guess, approvals of where wind should and shouldn't be. I think that the site-specific analysis makes more sense, because then you're doing a deep dive into whether that particular site should be developed for wind. And at that point, then you are taking into consideration the public comments and whether the public is receptive to wind development in the area. And I think that is maybe one of the most critical aspects. And I'm very grateful and thankful for the support that we have in Carbon County for our project, because I believe that that is a huge factor in any project being successful.
Okay, first of all, this one's louder. First of all, I'm not in the siting business, but I do have something to say about plans on where to site wind projects from a slightly different point of view than probably what my friend Ken Lay was going after. And that is the biggest hurdle in the state for siting wind and building out more wind is transmission. We don't have enough transmission. Now that's probably not an issue for Roxane's project because they're building their own, which is a great thing. As far as if you're just a standalone wind project developer, siting is going to depend on where is their transmission, and right now we don't have enough.
Thank you. In response to the questions, I always support review and streamlining, and again, making sure that we're not wasting precious resources to be duplicative. But I also think there's tremendous value in certainty and certainty for business. And as we're at a time where there could be some other open questions that are on people's minds as far as tax policy and
Types of development and industrial facilities. Right now, the burden is on wind to show reclamation, decommissioning, financial assurity, financial capability. I think that should be true with all types of industrial projects that come to this state. The one thing that is a little bit concerning that I've heard from other folks is, what about other renewables such as solar, geothermal? They also have impacts. They require workforces to come in and construct, but yet maybe their construction costs aren't as high to meet the construction cost threshold. So I think that's something we should think about. Plus, if Wyoming's going to sign up for good, viable projects, they need to know, not just with wind, but with other types of projects, that things will be adequately decommissioned, reclaimed, and that we're getting the best of the best developers here who do have the financial wherewithal to construct and operate and maintain these projects. With respect to the other question, I agree with Roxane. I think site-specific analysis is always the best. There's a lot of things that go into decisions with respect to where to construct wind energy projects. From willing landowners to the finances to getting it to the grid. So I'd rather than just a blanket, you can build here and not here. I'd rather see the individual site analysis.
Great. Thank you. Questions from the audience? Ann?
I don't know if I can speak loud enough, but thank you. When you're saying that the individual site analysis is the best, I used to pay a lot of attention to industrial siting. I haven't lately, but I don't recall that industrial siting has very often, or perhaps ever, denied a permit. So I wonder how the sort of concerns about that we've seen on these statewide maps about that there clearly are better places from probably both a wildlife and maybe a viewshed point of view for it to be built. How does that truly get taken into consideration when it seems unlikely that a permit is going to be denied?
Well, I guess my thought is this. Up until now, I guess back when I first started doing industrial siting work, there weren't a lot of agency comments. There weren't a lot of public comments. There weren't a lot of involved stakeholders. It was sort of new to people that they could participate in the process and make their views known. I think with the improvements to the Industrial Siting Act, more awareness of people's concerns with wind energy, I think there are opportunities within the industrial siting process, such as agencies, state agencies that their concerns are like game and fish, wildlife. If there's a specific area that they're really concerned about, it's incumbent on them, and they have the ability to comment through the industrial siting process and to make the council aware of their concerns. So I think, those who do have viewpoints, there are lots of opportunities to make those known, and I think the council will consider those. But when people don't show up and make their viewpoints known, I don't think the council has any choice but to grant the permits. And if there are opportunities to impose conditions on permits to address concerns, then the council is informed and is making an informed decision based on the expertise of that state agency or of the party that is allowed to participate or public comments at large.
Other comments? Stephanie?
Thanks. I have a question for Roxane, and I first want to thank you and Power Company of Wyoming for the broad outreach that you've done to stakeholders in your process. I've actually toured the site twice and have seen and learned about the research that you have been doing and that you mentioned today. And my question is regarding that. Is that research and the results you're coming up with, is that proprietary, or are you required to share that with the Wyoming Game and Fish Department so that we can all learn what you were learning about mitigation for wind?
We have shared data with Wyoming Game and Fish Department, and actually we are working with Wyoming Game and Fish Department on certain research. The sage-grouse research in particular has already resulted in papers and presentations, and will continue to result in papers and presentations that are shared with the public. But the short answer is yes, we have been sharing data.
My question is for Roxane. Rick Grant, Commerce County Commissioner. Having gone through this process as well through the industrial siting, are you at liberty to share your upfront costs, what it has taken to get you to where you are today without any revenue source coming in, the amount of studies and where you're at?
We've spent hundreds of millions of dollars at this point to bring the project to where it is today.
Yeah, I'm the RTO of the Regional Transmission Authority. I wondered if the gentleman could just elaborate a little bit on your gut feel if we can overcome this depoliticizing the California piece and truly get some kind of a RTO that will have buy-in enough where the West will participate.
Right now, my honest assessment is not good. What's happened over the last 2 years is the plan was that the next step was the governor of California, Governor Brown, was supposed to present to the legislature a plan for regional governance by the end of 2016. Instead, it became clear to him that there were too many issues, and he was very much aware of the conversations going on between the states. And by the way, those conversations between the states included California as well. And it was all done very politely with one another, and we agreed to disagree. Then 2017 came along, and this summer another piece of legislation was put together to try and get that accomplished by the end of 2017. And on the last day of the legislative session in California, the sponsor withdrew it, knowing that he didn't have enough votes to pass. And so they agreed to try again in 2018. But I frankly cannot see the possibility of enough movement in the state of California that they would be willing to allow the regional western grid to be managed and controlled by a totally independent body.
I have a question for Roxane. First, I greatly appreciate your transparency in sharing the data that you've acquired during all your studies, and I'd like to follow up on Stephanie's question. It's wonderful that those data are available. Where can a person find them?
In terms of the peer-reviewed papers, I'd be happy to try to get your email and send you some links to where those might be. They've been presented at various conferences, but I'm sure we can find the papers that have been published. Otherwise, our data sharing has been mainly with Wyoming Game and Fish. Certainly some data is confidential, but when we're working with an agency, we're sharing data with them on certain studies. But I'm not meaning to say that all of our data is public, because that is not correct.
I'm the non-game bird biologist for the Wyoming Game and Fish Department. So I'm in the Lander office, although I cover the whole state. I imagine that you share the data perhaps in our Cheyenne headquarters.
Well, you're getting above my pay grade. Let me give you the name of the person that does all of that, and I'll be happy to give you his contact information.
That's wonderful. Thank you so much.
This actually brings up a broader question that I asked the panel to address, and because over the last day and a half, the issue of data and the public availability and the proprietary nature of it has come up in any number of contexts. And I'd like your thoughts on this. I mean, Jen, you've dealt with this through the litigation process. Cindy, you and I dealt with it in the legislation. Bill, the Public Service Commission is probably one of the most transparent organizations, regulatory agencies, at least in their public dealings and the availability of their procedures to be in the public to be involved in it. What do you think? I mean, is Wyoming got the right set of laws and regulations governing how this data is used, or do we need to address it? And that's obviously a question, whether we need to ask some of the folks in the audience directly affected by this.
Now, to be sure I understand the question, you're talking about our public access laws broad enough, or?
Well, yeah. I mean, you get proprietary data in the course of a lot of your proceedings. So the question obviously is, how do you deal with that? I mean, the concomitant question is, in terms of your proceedings that are open to the public, how do you try and address those issues?
Okay, got it. It's a good question, and there's no simple answer, but we do get, in all kinds of different proceedings, we get a lot of exhibits and documents put before us where the parties are claiming confidentiality. We go through a several-step process with this. We first review, and more often than not, a party will declare an entire document confidential because of one page or half a page or whatever. So we will ask them to go back and redact the confidential portions so that we can have a public version and a private version. Taking it a step further, if you become a party to one of our proceedings, and basically anybody who has a cause, who has an interest, can become a party, then you can sign a confidentiality agreement, a protection order that would allow you to see everything unredacted, and you just have to make your promise that you will not share that outside of the room. We also, in some cases, have to close a portion of our hearings, or as in the last case, last Friday, we closed the entire hearing, first time that's happened in my 5 years. We will sometimes close them both for people in the hearing room. We also stream and transmit over telephones, and we'll shut that off for various parts of the proceedings that involve claims of confidentiality. And the fact is, some of the claims that come before us really are proprietary information that need to be protected, and some of them kind of make us scratch our heads in why they're claiming them, and we try and balance between the public's right to know and the party's private information.
I'll take a pass at that too. Just being so intricately involved with the business community as I am, there's a lot of sensitivity amongst competition, competitors. And I think in Wyoming we do a really good job on trying to problem solve, to maintain that commitment to transparency, to make sure that our citizens know what's going on and have access to information, particularly to have it be utilized in a helpful manner, in a research capacity, but also try to make sure that we're not, putting a potential developer at a competitive disadvantage by essentially laying out the secret sauce. You can't do that. So I think we do a good job. Again, the county commissioners were very instrumental in the review of the Public Records Act. That was another one of my past projects, working closely with the Wyoming Press Association. Again, I think a very good and reasonable outcome of that effort.
And I guess I'll address this from more the private side, developers and whatnot. Going through the permitting process, oftentimes my clients will say, oh, well, that's confidential. We can't give that to industrial siting. We can't do this. We can't do that. And of course, in order to get the permit, you're going to have to give up something. So what I try to do is to counsel clients to think about what is the information that Industrial Siting Council really needs to be able to approve this project. And I have clients tell me everything from reclamation, decommissioning costs are now confidential to you name it. But at some point, there's a happy medium that we've been able to get to with the agency with respect to the Industrial Siting Division's ability to do its work, to be able to make recommendations to the council versus what my client is often willing to give up or not give up. I also tell them that be careful, because anything you give to a state agency could be fair game, even if you do think it's confidential and you mark it as such. I've had other experiences with state agencies where they disagree, and the Attorney General's office is always, in my experience, erred on the side of disclosure. So whatever you do, be careful. And I've had clients that are like, oh, I didn't know. Well, anyway, it's sometimes we have to educate the AG's office too.
Want us to stop?
We will take one last question before the break.
Okay.
Thank you. I'm very concerned about confidential information. And oftentimes I wonder if that information, the data, has been collected professionally and how certified it is. And certification, oftentimes comes from other people have looked at it, and they have, professionals have looked at it and have given it that nod of approval. And I come from academia, and there, when we put something out, it goes through reviews within our department, it goes to the journal, it goes to reviews. We have to oftentimes revise. And I'm just very concerned about this confidential stuff. I've served on DEQ and some other organizations through the Environmental Quality Council, for example. And this issue of confidential information really bothers me. I had a chance to work with Jack Ward Thomas for about 10 years. He was the chief forester under the Clinton administration. And he came up with a really wild concept, and that is you make decisions based on best available information. What a concept, rather than ideology and that sort of thing. Now, oftentimes, there's not good information out there, but still, I think, and I've looked through records, confidential records from reclamation companies and that sort of thing, and there's fantastic information there if it is real, if it can be certified, if it does test. Go through the test of review, if you will. And I think it behooves any organization, whether it has to do with the Chokecherry Sierra Madre or whatever, any information out there that they believe is good quality information, getting it out, even though information is power, and oftentimes, other organizations will use it, but still, getting that information out is a public service. And I probably said as much as I should here. Shooting my mouth off. Thank you.
Thank you. Thank you very much. Let's give the panel